Well, hello, everyone. Welcome to our second economic crime conference. We put one on last year and it was a huge success, and we decided to repeat it again, but covering slightly different topics. So today we have a panel of real expert speakers, attorneys from around the world, presenting on global trends and sanctions and asset recovery. Our speakers are going to take a look at the impact of the Ukraine-Russia war and recent developments in the sanctions arena, how it impacts your clients, whether your clients are businesses or individuals. And we have practitioners presenting from different countries, from the United States, from the UK, India, France, Italy. And our first speaker today, all of these speakers are lawyers with extensive experience. I've known them for many years. They're not just great practitioners. I am fortunate to count them as friends. And I think they're all very exciting, engaging speakers. So we're lucky to have them today. First up today will be Timothy Mills. He is an attorney practicing in the United States. Tim has more than 30 years of experience in international economic sanctions arena, complex cross-border white-collar criminal disputes, commercial disputes. He represents some of the wealthiest families in the world and some of the largest companies. He represents sovereign governments, and he has litigated and represented clients before the US Supreme Court, the Supreme Court of Canada, the High Court of England and Wales, and so forth. He also has extensive experience working with national security, well, US national security, I should say, and defense industries. He has served as a lawyer with the US military and a high-ranking officer for many, many years. Tim, I am going to be quiet now and let you take it away.
Good morning, everybody. Give me a moment here to load the PowerPoint, and here we are. Today, I'm very privileged and honored to be able to speak to you on the topic of Russian sanctions today, tomorrow, and beyond. Particularly what I'll be covering is the newest, what's happening, including up through this morning, what's still to come, and how to respond. So let's take a look at the global landscape on sanctions. And this is current as of June, beginning of June. These are sanctioning countries in blue, the ones who have sanctioned Russia and in massive amounts. The red, of course, is Russia. And you see China in purple, which means they're not cooperating with sanctions, but they're not blocking them either. Green, and then, of course, very important, those who are not sanctioning. And particularly if you look, you see India in the Middle East. Middle East is something of a haven for Russian assets, and India is, of course, a major purchaser now, as it never was before, of Russian crude. So let's take a look at the magnitude of sanctions. The number of cumulative sanctions actions that have been taken against Russian entities is reflected on this graph, but probably is more easy to understand if you look at it in a histogram. The number of sanctions imposed against persons, more than 3,000, against vessels, which has to do with oil transports. More than 113 vessels have been sanctioned. Organizations, mainly state-owned enterprises in Russia, financial institutions in Russia that have contributed to the war effort, defense industry in Russia, legal entities in Russia, and also companies. And these, again, are state-owned companies in Russia that are major contributors to the Russian economy into the war effort. Let's talk about what the effect is on the business sector. And this implicates us as lawyers, in particular white-collar lawyers, because the current impact on sanctions is, if there's sanctions evasion or sanctions non-compliant, is a criminal matter. So that's why we're here today talking in a white-collar crime economic crime conference about sanctions. Well, what is the effect on companies, the international companies that were doing business in Russia? The fact of the matter is that more than 1,000 of them have curtailed operations in Russia, and more importantly, 247 companies continue doing business there, mainly from outside of the sanctioning countries, particularly China in the oil sector, India, and the like. But let's take a look at losses. Companies have experienced great losses as a consequence of having to pull out of Russia, $59 billion losses for the international companies. And look at who is affected, among others. Philip Morris, $5 billion loss. Apple Computer, McDonald's, AP Moller Maersk, who is, of course, a transport shipping company, Anheuser-Busch InBev, the Banque Société Générale, Renault, and I didn't list the American banks that have been hurt to the extent of billions of dollars. And what is complicating this? The Russian government response, which includes the threat of asset seizures, prohibitions on repatriation of dividends and exporting of key assets, and of course, threatening to arrest corporate leaders in Russia who either speak out or are deemed to have violated this law or the other law that would make them unfavorable to the regime. So let's move on now to energy impacts in the sanctions. The sanctions primarily were directed at stopping the Russian war effort, or impeding, I should say, the Russian war effort. The theory being, let's deprive Russia of the revenue needed to continue the Russian war against Ukraine. And here are the theoretical foundations. The 2021 Russian budget, the revenue from oil and gas sales abroad comprised 45% of Russia's federal budget. Revenue from Russian fuel exports now exceed what Russia is spending on the war in Ukraine. For example, in the first 100 days of the war, Russia earned 97 billion on exports of oil, gas, and coal, and 2/3 of this, 97 billion euros, was from Russian oil exports. So with this in mind, why is that the case? And you can see that no Russian sanctions have been imposed by India and China, and Chinese companies and Indian companies are snapping up Russian crude at highly discounted prices. Look at these figures. India jumped from 0 barrels a day in January 2022 to 700,000 barrels a day, and is buying it at a $20 a barrel discount from the international benchmark. And just 2 days ago, the Indian government encouraged their oil companies to scoop up even larger volumes of Russian oil for the national interest in India, which is to say, having cheap oil available at this time of inflationary pressures. And China has imported 800,000 barrels a day of Russian crude in May 2022 at extraordinary discount, again, of $20 a barrel below the Asian benchmark, which is the benchmark for Dubai crude. So what's new and in the near future and beyond? Expect both the EU, the United States, Switzerland, major sanctioning companies to increase the sanctions on the Russian oil sector, in particular, the sanctions that are aimed at Russian gas exports to Europe, which have not been imposed, but as of 2 days ago, Russia cut off gas to Europe. So there's no more practical impediment to imposing those sanctions. I think diplomacy will be aimed at India to reduce Indian purchases of Russian crude. And what kind of diplomacy? It would be to encourage India to buy from elsewhere. One of the aspects of that is when President Biden goes to Saudi Arabia to meet with the Crown Prince and the King, there will be encouragement given to Saudi Arabia to export more to India at lower prices than are being offered by the Russians, so as to wean India off of Russian crude and hurt the Russian energy sector or the revenue producing sector even more. And think that there's going to be further sanctions on shipping concerns and financial institutions and global insurers with respect to vessels that are transporting the Russian crude. There are already sanctions, as I said, on more than 100 vessels, but I expect that to grow. And those vessels that are sailing now are sailing with, this is very interesting, they're sailing without insurance. And I understand that there's a mechanism that's been put into place by the Russians to guarantee the cost of the vessel should anything happen, in other words, to self-insure. And the question is, how would that be paid outside? Because it'd be very difficult to pay in something other than rubles. So let's look at the financial sector. Initially, the Russian central bank and most of the major Russian financial institutions were sanctioned. The Russian reserves that on account in the United States, more than more than I think, well, the figure is in the billions of dollars in any event, were frozen, and those currently, there's pressure on the US to seize those assets rather than seize ownership of the assets rather than strictly freeze them and then use them to pay Ukraine for damages, but that hasn't happened yet. There's blocking sanctions and dealing sanctions. Dealing meaning you can't deal with somebody who's sanctioned, blocking meaning the assets are blocked, cut off from SWIFT network for many Russian banks. Well, what's new? An extension of these is even being made. For example, in the energy sector, the banks that were handling the transactions for Europe were not sanctioned, but now there's a move to sanction even those banks and strengthen this internationally. Past and present export controls, very, very important. And this is something that white-collar criminal lawyers are involved in, and so are trade lawyers. There's been a prohibition on export of most technology to Russia that could be used in the war effort. You hear the anecdotal stories that Russian weapons that have been found in Ukraine after they've crashed, say, for example, missiles. They found, instead of advanced chips, they found chips that were put in washing machines and dishwashers. So that indicates that these sanctions are biting and hurting, and 70% drop in technology exports across the board from Europe and the United States into Russia. But again, focus on Russian shipbuilding, aerospace, and defense. But what is the reason for strengthening these? Well, here we have it. What does the Canadian intelligence say? It says that Russia is actively looking for ways to circumvent sanctions, to acquire Western military technology and components. And then the United States is saying how dependent the Russian military industrial complex is on these sanctions, and that Russian sanctions evaders are some of the most skilled, highly, let's say, manipulative people in the world today. And they are in the process of setting up all kinds of shell companies. And this is one of the reasons why in most US embassies abroad, you have the Treasury Department putting people in place to detect this and to access all the public records about new companies being formed. And the database on this that's maintained by the United States under terrorism finance and through the Financial Crimes Information Network set up inside the Department of Treasury is immense, unbelievably immense. And this goes to the rubric that you can run, but you cannot hide. But that's what to expect in export controls and sanctions. So aviation sector, I think we're all aware that Russian aviation, civil aviation sector is being hurt tremendously. The aircraft that were leased have been called back. The parts and maintenance mechanisms that were in place through Boeing, Airbus, Bombardier, all of that is ceased. And so the airplanes are no longer airworthy. And we'll get to the leasing issue in a minute. But the European Safety Agency said just a couple of days ago, they're very concerned about the safety of Russian aircraft. It's unlikely, even after sanctions are lifted, that Russian aircraft are going to be certified to fly into other jurisdictions, including China, until they're shown to be airworthy. And so even after sanctions are lifted, this is something that's going to take several months to resolve. Let's look at leased aircraft. This is a very, very, very interesting sector legally, because the leased aircraft that weren't returned can be deemed to be stolen property and can be deemed to be able to be seized if they're outside of Russia or they're in a country that recognizes sanctions. And we'll get to that in a minute. But look at the numbers. 515 commercial aircraft were leased as of the beginning of February. Only 100 were returned. Of the 400 plus that haven't been returned, they're still in Russia and flying inside Russia and flying to friendly countries, what Russia calls friendly countries. And here's an example in Sri Lanka. A Russian Aeroflot A330 was seized on order of the High Commercial Court of Colombo. The Attorney General of Sri Lanka filed a petition, says, please release it because of the diplomatic pressure being brought by Russia. And it was released. All of this implicates, of course, insurance in the aviation sector. And as with the Iraqi Airways seizure of Kuwaiti Airways aircraft in 1990 that resulted in insurance companies paying that off and then litigating to recover that money from the Iraqis, which they ultimately did. I ultimately settled that in 2009 when it was brought in 1990. Think of that, 29 years of litigation. Well, what's happening now is that $3.5 billion in insurance claims have been made for aircraft that were not returned under the leases, and even more insurance claims are coming. Again, this is a matter of a combination of legal teams that are white collar criminal. If you're going to go into court and say, all right, fine, the aircraft are stolen, and experts in insurance and experts in enforcing those rights and asset seizures. Let's talk about block, freeze, and seize programs. And again, blocking sanctions and dealing sanctions. The dealing sanctions that prohibit any dealings with sanctions persons, and what to expect in the future. Again, continuous additions to the designations of people and entities will happen. And then in terms of freezing sanctions, again, a point here is that assets that are frozen or seized are not forfeited by virtue of being seized, and separate legal action is necessary to bring a forfeiture. And those legal actions are contemplated by the United States, but there are legal impediments to that under US law presently. So there's an expanded international search going on for concealed assets. More aggressive international freezing and legal actions will be taken in the future. Something very important to realize is that, let me go to the previous slide here, is that the US Justice Department and the US government has set up a very high level task force headed by the Attorney General to find assets that can be seized. And this is international in character. It's working with the Europeans through the EU organization called the Transatlantic Russian Sanctions Task Force. So there's a worldwide effort to seize assets that are currently hidden. And I might add that they're very well hidden. Dubai and UAE, are places where they are hidden. And so this is something I really want to bring to your attention. What's new, future and beyond, an asset seizure enforcement whistleblower program. The Department of Treasury has set up under US law a whistleblower program. If people have information about where oligarch assets are or Russian assets are that are frozen or should be frozen, and they come forward with that information, and that information leads to the seizure of those assets, there's a $5 million reward of up to $5 million to be provided to such people. And that's something that is able to be accessed now, meaning that program is able to be accessed now. It requires some expertise to make sure if you have such people as clients that they do meet all the requirements and all I's are dotted, all T's are crossed, so the US can't wiggle out of a rewards situation. And let's talk about what to respond. And as lawyers, we're all concerned about ensuring that our clients don't suffer any woes or legal peril. And in the area of sanctions, it comes down to compliance, 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 strict compliance with all sanctions laws and new export controls. And here's what the Treasury Department of the US has said your sanctions compliance program should look like. I encourage you to download this US Treasury Framework for OFAC Compliance Commitments. It's a 7-page document, single space, it goes through it. But what is it based on? Well, 5 factors.
Tim, I'm sorry, I need to interrupt you. You're out of time.
All right.
And we need to move on to our next speaker so we can keep the whole program on time. Thank you so much. We learned a lot about the effect of sanctions, certainly, and it's troubling to see how, at least in the short term, Russia is able to make more money as a result of sanctions and not be hurt by them. So thank you so much, Tim. Our next speaker comes from Aliant's Italy office. Nikita Plako has been practicing law since 1995, and his specialty is white-collar criminal law and business crimes. He has represented some of the leading, most notable companies in Italy with criminal matters of all sorts. And particularly, Nikita advises on public funding and compliance with the Italian legislative decree called 231, which he'll tell us more about right now. Nikita, you ready to go?
Yes, thank you, Jacob. Thank you all for being here. And I am very honored to be invited to give my presentation, trying to move my picture, my screen from here. But my presentation is focused on sanctions and precautionary measures within 231 compliance programs in Italy. And this is a new discipline, or relatively new discipline, that has been issued in 2001, of course, based on the authority delegated to the Italian government to adopt a legislative decree, the purpose of which was to regulate liability of legal entities and companies arising from offenses committed in their interest or advantage by their representative. So on that basis, the Italian government issued the legislative decree 231 that is very well known in Italy as 231 compliance, or eventually decree 231. This is given to many criminal attorneys, as I am, the chance to enlarge the practice from the defensive, the defense before court to a physiology phase that is made to avoid, to prevent the commission of crimes within legal entities and to try to avoid this administrative liability. According to the legislative decree 221, bodies are liable if a representative commits one of the listed offense and the offense is committed in the interest or advantage of the body. We have been discussing a lot in Italy about the nature of such liability because it comes from offenses, so from crimes, but it's actually not qualified as criminal offense. It is called an administrative liability arising from crimes. We have been agreeing that at the end, in the end, it's a third kind of liability, and this is because in Italy we have always been applying the principle societas delinquere non potest, that means companies could not commit a crime, and this principle is stated in the Article 27 of the Italian Constitution that provides that criminal liability is strictly personal. So this new system of bodies liability could not go against that fundamental ground, but at the same time, it is totally based on criminal principle, and it is applied through the criminal code rules. Such liabilities is addressed to bodies instead of individuals and comes in addition with the personal criminal liability of the defendant. It is not purely administrative, it is not directly criminal, so we talk about an administrative liability arising from unlawful acts relating to offense. Coming to the sanctions, so the main subject of my presentation, sanctions provided in the 231 decree are actually four administrative penalties that are fines, disqualification, seizure, and publication of the decision. What about fines? Fines are applied on a quota system from a minimum of 100 to a maximum of 1,000. Each quota ranges from 258 euro to a maximum of 1,549 euro. And so this means that the minimum fine would be 25,800 euro and the maximum could be 1,005,449. Of course, the judge decides on the number of quotas taking account of several elements, which are severity of the act, degree of the liability, and the activity that the body has been performing to eliminate or mitigate the consequences of the act. Moreover, the body's economic condition are very important because the sanction has to be proportionated to its conditions. Second category of sanctions is disqualification, and there are five. First one is very severe, is the disqualification from exercising the activity. Second is suspension or cancellation of authorization, licenses, or concessions serving to commit unlawful acts. Third is prohibition on entering into contract with the public administration, and then there is exclusion from benefits, loans, or contribution or subsidies, and last, prohibition on publicizing goods or services. Disqualification ranges from a minimum of 3 months to a maximum of 2 years. Criteria for selecting disqualification measures are the same applied for fines, so the judge determines type and duration, taking into consideration the likelihood of each specific penalty preventing unlawful acts. It's very important to state that disqualification measures may be applied jointly. Disqualification from exercising the activity is only imposed when other forms of disqualification are insufficient. Then we have to underline that bodies can avoid disqualification if prior to the beginning of the proceeding before court, they adopt 3 specific virtuous behavior, fully compensate for the loss or damage and eliminate all the harmful consequences of the offense, eliminate the organizational shortcomings that make the offense possible by adopting and implementing organizational models suitable to prevent the commission of such crimes or offenses, and make the profit obtained available for confiscation. Third penalty is confiscation. When convicted, the proceeds and profit of the offense are always confiscated from the body, save for a portion that may be returned to an injured party. And this confiscation is the main and autonomous penalty that has no subsidiarity relationship between the aforementioned penalty and the provision of the criminal code, setting out the same abrogative measure against the defendant. Last one is the publication of the conviction. Judge may order that the conviction be published when the body is disqualified. Of course, the disqualification is an essential prerequisite of the publication, but the publication is not a corollary of the disqualification, and it has a sanctioning effect, and because it has an impact on the image and integrity of the body. These are all the penalties. Then there are in Legislative Decree 231, there are for precautionary measures called interim measures. There are three types: disqualification, again, prior attachment, and attachment of assets. Disqualification are exactly the same measures as the penalty, but applied as of interim measures. And what is very important to underline are the requirements that might take a public prosecutor to request a judge to apply one of those measures or by way of an interim measure. So serious clues, serious circumstantial evidences that the body is liable for an unlawful administrative act, and the real danger that that act might be repeated, so might be committed a second act of the same kind. All the interim measures must be proportionate to the severity of the act and to the penalty which is deemed to be imposed on the body. Very interesting is that as an interim measure may not be applied jointly. The duration of interim measure cannot be longer than 1 year. Second interim measure is prior attachment, when there is danger that the free availability of something pertaining to the offense could aggravate or prolong the consequences or facilitate the commission of other offenses. Court may order attachment of the assets, and requirements are again serious clue and possibility to confiscate proceeds or profits of the offense. Third and last interim measure is attachment of the assets. If there is a well-grounded reason to believe that the guarantees for payment of the fines or court costs or all other sums due to the state may be missing or dispersed, public prosecutor may file to the judge a motion for attachment of the body, movable and unmovable assets. What is really important to bring your attention to. Bodies can preemptively avoid disqualification penalties, but not disqualification interim measure. So the same measure might be avoided as a penalty and not as an interim measure. And this is meaning that if during a criminal proceeding, public prosecutor retains to have serious clue of the offense, my request to a judge to apply as a disqualification interim measure that's so severe as to impose the stop of the activity to any company. So the three virtuous behaviors that I've been already mentioning fully compensate for the loss or damages and eliminate the consequences of the offense, adopting and implementing the organizational models, and make the profits obtained available for confiscation are reasons on which a company, on a legal entity, may base a request for suspending the interim measure and can obtain a revocation of that one. But of course, the point is that this might happen only after that disqualification interim measure has been already applied before having been judged liable by the court of merit. So just arriving very quickly to the conclusion, what is very important to state is that the adoption of an appropriate organizational model for the prevention of offenses can avoid serious penalties and severe interim measures for legal bodies and companies. Adoption of the model has not been foreseen as mandatory, but it is strongly recommended. And I can tell you that in more than 15 years practicing on this matter, I've been having the chance to cope and face with a lot of different and several issues within companies that were not directly related to crimes or offenses, but have helped us to avoid that situation. Thank you all for your attention, and I remain available for any clarification you need.
Thank you so much, Nikita. You're certainly very knowledgeable on this topic. Thank you for the input from Italy. Okay, next, one of our speakers from the UK, Paul Garlick. So we are placing a lot of emphasis in this presentation on the UK because there are so many, I guess, Russian nationals who live in the UK, Russian oligarchs. There are a lot of Russian money in the UK. So UK is sort of in the crosshairs of a lot of this stuff. And our first speaker from the UK is Paul Garlick. Paul is one of those lawyers where I can easily spend the next 2 hours just relating to you guys his professional CV. Paul is Queen's Counsel. He is one of the most renowned barristers in the UK, especially on the subjects of international law and extradition proceedings. He represents not only individuals, but also foreign governments with respect to, and I guess UK government, with respect to extradition and human rights issues. And he is probably one of the best known lawyers in the world on those topics. So Paul, perhaps you can share some of your experience and knowledge with us. Paul, we cannot hear you.
Always make that mistake, mute and unmute. Good afternoon, friends and colleagues. Thank you, Jacob, for your very generous, over-generous introduction. I've only got 15 minutes, so a lot of the slides that I've put up and will be available to you are very technical about extradition, and I'm not going to go through those because I want to concentrate on some of the innovative aspects of litigation which we all may be able to benefit from for our clients over the next couple of years in connection with extradition. We've already been in the UK here, in London, we've been working with Aliant lawyers in the US on a very interesting extradition case involving non-bis in idem, autrefois convict and convict. It's been fascinating. And there's a lot of scope, I think, for work for us all. So you'll see on the slides, I've set out what is the basic new scheme for extradition between the UK and the EU. And I've done that because it has fundamentally changed our relationship with the EU, and it's changing by the week. There are going to be some dramatic movements, I think, in the next couple of months in extradition proceedings between the UK and the EU. It will also have an effect for our non-EU partners around the world. for reasons which I'll explain later. So following the end of the transitional period, which ended on the 31st of December 2020, of course, the UK is no longer part of the EU, and so we have been dropped. We've been unceremoniously dumped by our partners in the EU. We're no longer a member of the European Arrest Warrant, which was probably one of the most effective tools for extradition around the world in the last many decades. But there is a new agreement between the UK. I'm not going to go through the technical details of it, but any of you who do get involved in litigation will see from my slides the technical aspects, and I've set out where you can find the legislation, because the legislation is still in our Extradition Act of 2003, but it's obviously been amended, and all the details are on the slides, but I'm not going to go through them, except to explain. In extradition between the UK and the rest of the world, there are now two categories of requesting states. Requesting states are simply the state that is requesting the rendition of the fugitive. Category 2 states, and I've set them out on the slide, you'll all see, well, this is category 1. There are two categories. The first category is category 1, which is really the equivalent of the old EU partners, with the addition of people like Sweden and others. So they're category 1 territories. That's still the simplified scheme of extradition between the UK and our former EU friends. Well, they're still friends, and I'm still European. So in these categories, the process for extradition is pretty simple, but I want to talk about the category 2 territories as well, everybody else except our EU partners. And again, I've put out a complete list. You'll see it includes the United States, some very strange bedfellows as well. The Russian Federation. I can't imagine we're going to be extraditing anybody to the Russian Federation for some time, but technically they're still extradition partners. We'll see how that works out. Now, you'll see there are two categories. Within category 2, there are two categories, type A and type B. And interestingly, the difference between the two categories is that in category type A, the requesting state does not have to provide evidence of a prima facie case, or as you would say in the US, a probable cause. It's interesting, the extradition arrangement between the UK and the US is a bit one-sided. When the US makes an application for extradition to the UK, you don't have to provide any evidence to show a probable cause, or what we would call a prima facie case, whereas under the existing arrangements, if we make an application to the US, we still have to provide a prima facie case, a probable cause. That's type A. Type B, well, there you are. They're all there. All our old Commonwealth friends, and they do all have to provide a prima facie case. So in extradition with these territories, you're going to be considering not only the law of extradition, but also the evidence and whether there is a prima facie case. I've set out the process for category 2 territories. We don't have time to go through them now, but you'll be able to see them if you're ever involved and work through the process. And I've also explained how an extradition hearing works in the UK, the agencies involved, the Crown Prosecution Service, who is effectively our state prosecutor, will always represent the requesting state, and then the fugitive will be represented by people like us. I've also dealt with appeals, and I've also dealt with the role of our Secretary of State, that's our Home Secretary, in making the decision to extradite. You can look at those if and when you need to. And there are also bars to extradition. These are really the defenses. When you're defending an extradition, if you can bring your case within one of these bars, then extradition cannot take place. And you'll see, obviously, the big one is at the top. The person could face the death penalty unless the requesting state gives an adequate written assurance that the death penalty will not be imposed. And I'm not actually proud, I'm a bit ashamed, because this law was actually changed as a result of a case that I was in. I represented the United States government in a case called Suring which is a request for an extradition for murder, which had been committed in the Commonwealth of Virginia many years ago. And as a result of this case, it went through all our courts, right to our Supreme Court. I represented the US, and our Supreme Court said, yes, extradition to a country where someone might face the death penalty is lawful. It's within the treaty. It wouldn't actually be lawful now for the UK because we've now signed a protocol to the European Convention which prohibits the death sentence. But at that time, it was still open to the requesting state to execute someone who'd been extradited for murder or for any offense which attracted the death penalty. That case went all the way to the European Court of Justice, and in the European Court of Justice, I lost magnificently, and I'm jolly glad I did because it taught me a lot about the death sentence, and I could certainly never advocate it anymore. But these are the bars to extradition. You can look at those if you do have a client, and you can see if you can bring it within one of these fields, then that's an absolute bar to extradition. I've only got 7.5 minutes to go, so I've got to get a move on. Now I'm dealing with the new scheme of extradition to the EU. There was a transitional period when we were halfway in and halfway out of the EU, and that ended on the 31st of December 2020 when Brexit Day came along. And days before that, we hadn't actually worked out a new scheme for extradition, and lawyers just did not know where they were going. At the very last minute, we did enter into an arrangement, and it became part of the legislation which led to our leaving the EU. All the details are on my slides. What are the effects, though, of this change? Because the UK is no longer in the EU. Well, the most devastating effect is that the Court of Justice of the European Union, which ultimately had supervisory jurisdiction over extradition, because extradition is an EU law matter under the framework decision, the CJEU has no more jurisdiction because we've left the EU. And indeed, the Irish government, still obviously in the EU, they were very concerned about this. They referred a case to the Court of Justice of the European Union saying, look, should we extradite post-Brexit? Because post-Brexit, there won't be any supervisory jurisdiction by the Court of Justice of the European Union. The prison conditions of the United Kingdom are appalling. They definitely amount to inhumane and degrading treatment. Are we allowed to extradite? Well, the CJEU eventually helped Ireland, and extradition was deemed to be lawful, subject to, obviously, human rights issues. And that has been preserved to an extent. But we've got to look at the effects of Brexit. What is the difference now between pre-Brexit extradition and post-Brexit extradition? Well, we've really just dropped one word. The European arrest warrant now has just become an arrest warrant, but there are some real differences. And for those of you practicing in the EU, these are just a summary of some of the differences between the two schemes of extradition. Post-Brexit, some of the assumptions about dual criminality have gone. Previously, under the framework decision, there was a presumption of dual criminality. A prosecutor in Italy or any EU state didn't have to show dual criminality because the offenses were all listed in the framework decision. That is not strictly still the case, and you're going to have a look. I've jumped the slide. You're going to have a look, have to be concerned about dual criminality. Now, what's happening here? I don't seem to be able to move my slides along. Yes. You need to look, I'm just trying to find this out, get this right for you. So yes, the exemption from having to prove dual criminality now depends upon each foreign state. They have to sign up under the new regime to say we don't need proof of dual criminality. So depending where you are in the EU, the UK may or may not have to establish dual criminality. In other words, that the conduct which allegedly took place in the UK, if that conduct took place in your jurisdiction in the EU, it would amount to a crime punishable with usually at least 12 months imprisonment, For the bribery offenses, it's 3 years imprisonment. And the second big difference is the extradition of nationals. Previously, we always extradited even our own nationals. Even in Germany, where it's part of the constitution, under the framework decision, there wasn't an obligation to extradite your own nationals. That has changed. And each EU member state now has a right to opt in or opt out of extraditing their nationals. Usually, if they don't extradite, they prosecute within their own jurisdiction. So, interestingly, Germany, Austria, and Slovenia have already notified the authorities that they will not extradite their own nationals. They'll prosecute them within their own jurisdiction. And I think it's likely there are going to be a lot more people joining that list. I'm going the wrong way. Let's carry on. Come on, computer. Yeah. Now, this is really the nub of my presentation about future litigation. I hope I've got enough time to tell you. I've got 2 minutes and 39 seconds.
You can take 5 minutes, Paul. You're fine.
Okay. Well, this is source of good income in the future. So the Trade and Cooperation Agreement, which is the Act of Parliament in the UK that dealt with the departure, makes it clear that we're still going to adhere to the European Convention on Human Rights. Well, that was a year and a half ago when we left. Things are happening very quickly. If you're a member of the European community, if you're a member of the Council of Europe, which is different to the EU, it's now 46 member states. If you're a member of the Council of Europe, you have to be a signatory to the European Convention on Human Rights. If the UK government withdrew from the European Convention on Human Rights, and I do think that's the agenda of our government at the moment, they're using the present crisis about immigration to whip up popular support from withdrawing from the European Convention. If we withdrew from the European Convention, we would be thrown out of the Council of Europe. That has to happen. If we did, extradition would be on its head. At the moment, rulings of the European Court of Human Rights, that's the court in Strasbourg, not the Court of Justice in Luxembourg, it's the European Court of Human Rights, are binding on the UK. And here lies the future, I think, for us all to challenge future requests. If the UK asks for the extradition of one of your clients, it's perfectly clear that what's happening now, oh, come on, please. What's happening now is that I've lost my slide again. What's happening now is that the government is almost committed to withdrawing from the jurisdiction of the European Court of Human Rights. Just this week, on the 21st of June, our Justice Secretary, Dominic Raab, confirmed in the House of Commons that the UK, whilst it won't leave the European Convention at the moment, because it's an international agreement and it would be difficult. He said that under new legislation, which they've now introduced into the House of Commons, the British courts and ministers, so that's not just the courts, that's part of the executive as well, would not, and this is his words, would not always need to follow case law from Strasbourg, which is the European Court of Human Rights. This is a bombshell. I think that most EU member states, I've run out of time, as you can hear, most EU member states, if we withdraw from the jurisdiction of the European Court of Human Rights, will find that a basis for refusing extradition, because there'll be no supervisory jurisdiction. The Court of Justice of the EU has already gone out of the window. If they take the European Court of Human Rights out of the window, and it's entirely a matter for the domestic UK courts, our partners in the EU are rightly, I think, going to say, look, this is not on. We will not be able properly to police any possible violations of human rights if we extradite back to the UK. And this, I think, is going to be great scope for litigation for us all. The evidence is overwhelming. The prison conditions in the UK are certainly probably a violation of Article 3 of the Convention, possibly a violation of Article 2. We've had so many deaths in prisons from attacks and from COVID. So this is a great area for litigation between the UK and our EU member states. And I look forward to helping any of our colleagues in the EU with such litigation as and when it arises. That was a real gallop through extradition, I'm afraid. It's all on the slides, and I'm now going to hand back over to Jacob. Thank you for your patience.
Paul, thank you. You have convinced me that you know a couple things about extradition. It's very nice, always very nice to have a speaker who is both so knowledgeable and so passionate, and it really comes through. Thank you, Paul.
Thank you.
Our next speaker comes to us from India. Menaka Guruswamy is a senior advocate at the Supreme Court of India. She's a former lecturer at Columbia Law School, and she has been involved in many significant landmark cases in India and a wide variety of subjects. I can't speak today. Menaka just wrapped up litigation before the Supreme Court of India on a case involving prevention of money laundering, criminal asset recovery, and so forth. She's highly experienced in this area. And Menaka, we look forward to your presentation. Please take it away.
Thank you so much, Jacob, and thank you to the organizers for having me. I don't have a presentation, so I'm going to have to make do with, just hopefully having an interesting conversation with you. So I'm going to use the next 14 and a half minutes. I'm going to structure it into three parts. One, I'm going to talk about the sanction regime that India is not part of, and what we're doing with crude, very briefly, that Tim has already dealt with. Second, it's a great time to talk about money laundering statutes in India. The principal money laundering statute, the Prevention of Money Laundering Act 2002. We challenged its constitutionality on grounds of, violating due process and self-recrimination protection, so on and so forth. We've just finished arguments, and I'm awaiting the judgment from the Supreme Court, the panel of judges hearing it, which we expect when the court reopens around the 11th of July. And the third segment of this conversation is the reality of what is, money laundering prosecution and what is money laundering conviction. What does that look like in reality in India? So first, I couldn't but help think about the sanction regime that we are not a part of. So as Tim's already told you, India today, as of June 1st, India is now importing 1 million barrels of Russian crude every single day. There has been a 25-fold increase in our imports of Russian crude since the start of the war in the Ukraine. So that is an extraordinary kind of change of economic practice and economic activity. We're getting Russian crude at a reasonable price, at a deeply discounted price. And it's the reason why today the government of India is able to keep fuel prices at something that appears to be reasonable at this moment of time. And obviously we can see the impact of rising fuel prices. When I was last reading American newspapers yesterday, the president of the US, Joe Biden, is considering a gas tax holiday because I think gas in America is now a little under $5 a gallon. So that is, that is very expensive. India's behavior is, in the context of, importing Russian crude is very much in consonance with, its behavior when it's come to sanctioned countries for the last 30, 40 years, starting with our use and import of Iranian oil when Iran was under sanctions. So it is no different today, and it is, in India's opinion, in our best interest to buy reasonably priced oil wherever that comes from. I think as lawyers, the couple of real issues which are going to arise is one, when the European Union and America start imposing restrictions on insurance of ships that are moving Russian oil, because 2/3 of the ships that bring Russian oil to India are actually European ships. I think also the Indian practice has changed where we're using Russian crude, we're turning it into products like diesel, like jet fuel, and selling it back at present to European buyers. So it's going to be interesting to see what happens to some of our clients when that goes forward, once sanctions kick in to the level that they're expected to kick into in the next 6 months, when it comes to European buyers, European companies buying from India these refined products. I'm obviously thinking about all of this because I've got I write a column in a leading Indian newspaper, and tomorrow the topic of my column is actually called, to put it crudely, which talks about India's imports of Russian crude and what do we expect in terms of insurance, in terms of shipping, and what does that look like in terms of our own laundering laws, so on and so forth. Now, the second part of this conversation is really sort of to focus on money laundering laws, the anti-money laundering statutes as they exist at present in India. And essentially, I say at present because its constitutionality has been challenged, and we have challenged the constitutionality of money laundering laws in India on principally 3 counts. One, an overly broad definition, whereby we've argued that Section 3 of the Prevention of Money Laundering, the statute 2002, is overbroad. It defines almost everything as proceeds of crimes. It essentially says that anything that is directly or indirectly thought to be by investigators to be proceeds of crimes would in fact result in a money laundering charge. But the 2 principal grounds that we have challenged India's money laundering legislation as being unconstitutional is, one, the wide sweeping powers that the agencies have, the investigatory agencies have, when it comes to search and seizure of assets. So just to give you context, right, what is the reality of the money laundering legislation? Since 2005, when India's anti-money laundering legislation came into force, since 2005, and we're now in 2022, so a little over 17 years, whereas yearly the agencies raid, seize assets to at least 500 to 600 individuals or companies every year. Since 2005, we have had 11 convictions. Since 2005. So over this period of over 17 years, we've had 11 convictions. So what does this mean? This means that the process is intended to be the punishment. And what do I mean by saying that the process is the punishment? So for instance, the case that I was arguing before the Supreme Court, and I was using that case to challenge constitutionality of the provisions, if the allegation by the agency was that my client had laundered X amount of money, the assets of my clients that were frozen amounted to about 200x. And those assets are frozen and kept out of play till you have a conclusion of trial, which is extraordinary. So a trial in India, a criminal trial, any trial, can take up to 10 to 15 years. So you're effectively saying that if you are a company or an individual and you are accused of money laundering offenses, then a disproportionate scale of assets of yours could be frozen and set aside. And as a company, you would not be able to withstand, this kind of process for the next 10 to 15 years. So there is no proportionate correlation to the allegation or the quantum of laundering and what has in fact been taken away and what has in fact been frozen. So we've challenged this on these wide grounds of search and seizure. We have also challenged this as it being violative of the Indian Constitution's protections against self-incrimination. So one of the things that the money laundering statute in India does is, if you are called in by the agency, you are not entitled to a copy of the principal preliminary complaint that is made against you. So I will be called in without a copy of the ECIR, which is the preliminary complaint of laundering. I will neither me nor my lawyers will have access to that preliminary complaint. I am called in and I can be interrogated without lawyers many days running, and I can be arrested with limited access to bail. So these are the principal grounds on which we have challenged this money laundering statute, because unlike most other areas of criminal prosecution and criminal law that are provided for in the Indian Penal Code, where you have a right to bail, you have an absolute right against self-incrimination, and you have a right to a copy of the complaint or the charge that is filed against you. When it comes to allegations of money laundering, I have no such recourse. So this is broadly the grounds that we have used to challenge the law in question. And, we are hoping for a judgment, early July or mid-July. Now, when it comes to the specifics of the statute itself, and I'd like to run through some of the specifics of the statute, because we are looking at an overly broad statute with very minimal protection for accused, yet that overly broad statute with very minimal constitutional protections or no constitutional protections for the accused has resulted in very few convictions. Of course, we can have a larger conversation on how best, if you really wanted to attack a certain allegation of crime, what best is a measured, precise, reasonable statute the way forward, or is it an overbroad statute with very wide and disproportionate powers to the investigatory agencies the way forward? But leaving that kind of classical debate aside, I'd like to use the few minutes I have before, I'm guessing that Jacob will remind me and tell me if I have a few minutes to go. I'd like to talk about the specifics of the Prevention of Money Laundering Act 2002. One, and I have these notes, I'm happy to share them with you later. But one, the overly broad definition. So Section 3 of the Prevention of Money Laundering Act, which is the main principal provision, the principal critical provision of the statute, says this, and you'll see the language of it: whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use and projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. So really a direct or indirect attempt to indulge in any process, direct or indirect assistance in any process or activity connected with the proceeds of crime, or being directly or indirectly a knowing party to being involved in any process or activity connected with the proceeds of crime, and projecting or claiming those proceeds of crime as untainted property, results in an allegation, in a charge of money laundering by the Enforcement Directorate, which is the principal agency tasked with addressing issues of money laundering and allegations of money laundering. Now, what is a proceed of crime? Section 2U of the statute says the proceeds of crime means any property derived, obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Now, the schedules in the statute has been another ground of attack, of constitutional attack, as we have argued. What this simply means is that you need a scheduled offense, a schedule under the statute to attract the provisions of the statute. Now, principally in 2005, when the act was brought into force, very few offenses were considered scheduled offenses that warranted this nature of a very strong, stringent statute, which reverses the burden of proof, which has limited access to bail, etc. There were very, very few offenses: terrorism, counterfeiting currency, so on and so forth. There were hardly a handful of offenses which constituted a scheduled offense, which would result in a laundering charge. Today, systematically, in the last 17 years, almost all offenses under the Indian Penal Code have been brought into this category of scheduled offenses. Those include, surprisingly, things like copyright offenses, art fraud, so on and so forth. So a lot of things have now been expanded and have been turned into what are called laundering offenses. That simply means, therefore, that the agency and the state is able to tack on a laundering charge, which therefore means that you will be charged and tried in a laundering court in parallel with a regular criminal court if you have other offenses against you. Whereas in a regular criminal court, you have standard protections of criminal law, self-incrimination, knowing the complaint that is made against you, so on and so forth, the right to an attorney at all stages. In the laundering court, you don't have this. So we often have clients who have parallel proceedings being initiated against them, both in a laundering court where they don't have a right to see the charge, and they have limited rights against incrimination, access to lawyers, so on and so forth, and a regular court. And the judge, it is the same judge who is hearing cases in both courts. And that is the issue. So the judge has, in fact, an extensive amount of information and very few protections that are afforded to the accused on one charge, and minimal information and maximum constitutional protections being afforded to that same accused on another charge. And that is, in fact, the other principal ground that whereas we have challenged this money laundering statute. So I think, you're at a moment in India where one, you are seeing increasingly allegations of money laundering being foisted on multiple, clients, companies, individuals, high net worth individuals. And you have, in fact, minimal protections being afforded to those very same players. So for lawyers who are criminal lawyers in India, a large part of our practice, in fact, has become laundering defense because of the sheer volume of laundering charges that are in fact coming to court. So that is one area of law, both I think for foreign clients who do business in India, as well as Indian clients who are old players in this country, that we are seeing this kind of an expanded, presence in court of individuals and companies on charges that we would argue are in fact forced charges. So I'm going to stop at this point, and I'm going to sort of end with this note, which is that we are at a very interesting time in India where you have multiple white collar legislations that are being brought into play. You have a moment where the government of India, when being confronted with a changing geopolitical climate, is in fact, has continued a well-established foreign and economic policy of doing business with countries like Russia, so on and so forth. And we're going to have companies and entities and clients that operate both in Europe, in America, as well as in India, in fact, having to engage this kind of dual regime. One, a country where they do business, which does not participate at all in sanctions, which has increased its profile in terms of doing business with a sanctioned country. And two, you do have widespread money laundering laws, both globally as well as domestically, that are also in play. So I'm going to stop at this point. Thank you very much for inviting me to this conversation.
Aneka, thank you so much for your presentation. You are so knowledgeable and passionate, and I love the fact that you did not have the slides and just shared your knowledge with us. It made it very approachable and engaging. Thank you so much. Okay, before we move on to the next, so the next speaker is our last speaker for this conference, and after he finishes his presentation, we'll go into a question and answer session. So as a reminder, you're welcome to submit questions through the Q&A button in Zoom. You're also, once we go into the session, you're welcome to raise your hand digitally and just ask questions that way. And also for the speakers, this will be an opportunity to perhaps expand a bit more on some of your topics or cover something you wanted to cover, but perhaps did not get a chance to cover. So with that, our next speaker comes from our London office. Muthapandi Ganesan is a barrister who specializes in proceeds of crime and international asset recovery. Pandi advises businesses and individuals on all aspects of criminal cases, including bribery, corruption, criminal and civil tax recovery. I presume you're not advising them how to, Pandi, but representing them when they're accused of having done so. Pandi is currently advising on complex confiscation and asset recovery proceedings. So Pandi, please take it away. Let's unmute yourself, please.
Jacob, thank you so much. I hope you can hear me and see me okay. And I'm really excited to be able to speak at this conference. And of course, speaking after Menaka, what an interesting range of issues and topics that she raised. And being a specialist in this particular area, I think I probably can spend hours talking to Menaka about all issues on proceeds of crime and how it actually works in real life. And of course, that's the issue. What you have as an intent by a legislation and what actually happens in practice, I think is really, really two separate and independent question, which of course changes depending on the country that you practice in. And luckily, we practice in the UK, I practice in England and Wales, and we have had proceeds of crime since 2002. And in fact, it came into force in 2003. So we nearly have about 20 years of experience in this particular field. And one of the things that happened after the Ukraine war was quite unexpected. And that's what I've been given now probably about 14 minutes to talk about, which is the Economic Crime Transparency and Enforcement Act of 2000. And, well, it says, you see, that's error, they should be 2022. This is something that has come about as a result of the Ukraine war. There has been a lot of talk over the last 5 years. How do we fight crime in terms of high-end economic crime? Particularly, how do you fight high-end economic crime involving politically exposed persons and persons who are able to have substantial legal advice, accountancy advice, tax structuring advice, and hide their assets and wealth? And there's always been a call for people to put up a register of ownership by foreign clients or foreign individuals in the UK, and particularly England and Wales. And there's been rumors of that for many, many years. Suddenly, one of the unexpected results of the Ukraine war was the bringing into force of this particular act. It was entirely unexpected. It was put to the government on the 1st of March. And as soon as it was put to the parliament, it was passed within 7 days. I mean, that is an incredible speed. And of course, one of the issues that the London government and the parliament wanted to target was the assets belonging to foreigners, particularly assets belonging to Russian-related wealth, Russian-related asset accumulation in the UK. As a result, we have this act where it's been divided into three parts. Part one is in relation to finding out who are the people who own assets in the UK, and of course, looking at where those assets come from. And secondly, unexplained wealth orders. I know many countries have different terms for those sort of recovery of assets. And third is in relation to sanctions. And in my very short time, I won't be looking at part three, but I do really want to touch upon the first two parts and how they in fact interact with the economic crime conference that we are talking about. And one of the biggest factors has been over the years and over the 20 years of learning has been, well, it's been very, very difficult for Proceeds of Crime Act 2002, which is the most important legislation available to deal with the issues surrounding the investigation, the recoverability, and the seizure of criminal assets. I understand there's some noise as a result of my computer. My apologies for that, but for some reason it has decided to come on suddenly, and I can't get rid of it. Apologies. But dealing with the act and its intent, the act is looking at the registration of overseas entities. So it is there to ask and provide an opportunity by foreign entities to say who is the actual ultimate beneficial owner of those properties. And in order to define that, first question is, who are overseas entities? The overseas entities are, at least means, a legal entity that is governed by the law of a country or territory outside the United Kingdom. So this piece of legislation does not touch upon the ownership of companies based in the UK. Secondly, what does the legal entity means? It means body corporate, partnership, or other entities. So does it actually include trust? The simple answer is no. And that's one of the criticisms that people who practice in this field have said, well, isn't it easy for many of the overseas entities and their advisors and their tax structuring individuals to say, well, actually, why don't you just do it as a trust? Then the law would not be applicable. Now, what does this law actually expects you to do? It expects you to take reasonable steps to demonstrate and register who are the beneficial owners. You need to know who the identity of those people are. And it is important, and it emphasizes that you must respond within 1 month in relation to any request for disclosure. So in terms of what a foreign entity has to do is to provide information on who the person who is the actual beneficial owner. Now, it defines who that person is. If that person holds directly or indirectly more than 25% of the shares in the overseas entity, or has 25% or more voting rights, whether directly or indirectly. And thirdly, a person who holds the right or directly or indirectly to appoint or remove a majority of the board of directors of the overseas entity. And finally, it's a person who has the right to exercise or actually exercises or has significant influence or control. So the whole idea of the beneficial owner is to be able to actually go beyond the company and look through it to see who is the actual ultimate person who has the beneficial interest and ability to control, manipulate, and exercise influence over that asset of the company in terms of what it owns. And where you have trustees of a trust or the members of the partnership or unincorporated association, or not the legal person by which it's governed, meet any of the conditions that is set out and the conditions we just been through, then they would be required to provide that disclosure. So as you can see, it is actually a very broad requirement, and it is entirely a new requirement. And the requirement is to register with the new Companies House Register. So once you register with the new Companies House Register, it means that you would be required to publicly tell the world who is the actual person who owns that asset. You would then get an identification number, and you're required to update it annually. And what is the impact of that in terms of registering new properties? There's a very interesting consequence is in relation to the land registry restriction, where they're saying any transfer of freehold or leasehold, which is for more than 7 years, would be caught up by this new act. Any new lease that's more than 7 years will be caught up by that, and any new charge. And the act has got real teeth, because any new registration will not be authorized or allowed by the land registry in the UK unless there's a compliance with this act. Now, that's the first part which I just wanted to touch upon and give a glimpse of how suddenly there's been a real knee-jerk reaction by the UK government to target foreign nationals and foreign wealth, which may be hidden behind a foreign entity. As also part of that mechanism of attacking foreign entities and foreign asset purchasing is the new additional powers as given under the unexplained wealth orders. We have had the unexplained wealth orders or disproportionate income orders in other countries like in Australia, in Ireland, and in India. Is an investigative order which allows you to look at income of a person and looks at to say how have they accumulated the wealth they have. it is a challenge to their ability to demonstrate that they have actually bought the assets with legitimate income. So a bit like Manaka was saying, it is a reverse burden of proof situation where you have the duty to demonstrate. And especially in relation to people who are politically exposed or people who are related to a person who is politically exposed. And the value is actually relatively low, which is only £50,000 before this act comes into force. And this is bearing in mind, for example, if you look at the property market now, even a one-bedroom flat in any part of London would at least cost you 200 to 300,000 pounds. So it would effectively, particularly in London, would capture any transaction that takes place in relation to that. And of course, this is in conjunction with the new register that they wish to bring. It doesn't come into force as yet in terms of actual activity, but it will do in due course. So it's a combination of attacking the public information available and then using that to bring these changes to the unexplained wealth order. One of the additional powers that's been given is the request and the legal demand for the responsible officers to provide statements, documents in response to a request. And additionally, what they have done is, instead of just looking at the income requirement, which is to say, well, your income does not match the number of assets you got, is to say, well, actually, there is an additional way of freezing your assets if we can demonstrate that the asset has been purchased, not just because we can't demonstrate income and expenditure and your wealth, but because it has come from an unlawful conduct. And they have defined that by adding the only times you can make an unexplained wealth order is Part A of 362B3A, where you look at the unlawful income and it's insufficient for the ability to purchase the properties, and also now the ability to look at it that the property has been obtained through unlawful conduct within the meaning of section 242, which defines the unlawful conduct. So what that means is now we have new provision and new powers that allows UK enforcement authorities to reach out, not only to request foreign entities to tell us who the ultimate beneficial owner of a property is, even though they may hide behind a corporate entity, but also then be able to go through unexplained wealth order or civil asset recovery, where they can really say, well, actually, this is a way to attack those funds that may have come from bribery, corruption, and any other form of illegalities. And how effective is these proceedings and these procedures? Certainly in England and Wales, they have been used extensively, but they have not been very successful. But in terms of figures, as a final minute, Jacob, if I may, it is for the last year, in total amount of actual recovery, not the paper order, but actual recovery, you're looking at about £200 million. And that is still a significant sum of money that is coming back into the state treasury fund as a result of bilateral cooperation between countries, as a result of international mutual legal assistance, but also as a byproduct of criminal investigation, specifically focusing on economic crime. And of course, I think that takes me up to my 15 minutes. Thank you so much for listening. I'd be very happy to answer any questions that you may have. Thank you, Jacob.
Thank you, Candy. Great presentation, very clear. And I do have questions. So we're going to open it up for a Q&A. Again, you folks, you're welcome to raise your hands digitally, or just type them in into the Q&A chat box. And while folks are thinking of their questions, I'll start because I thought of a couple of questions first for Candy and then for Tim. And I guess for all the speakers to this extent. So, you know, we're lawyers, we represent clients who are not per se interested in what the law are because they're not academicians, right? They're not lawyers. they're looking at, at this as, and trying to ask themselves, like, what is it that I'm allowed to do within the confines of the law, right? How do I buy real property in the UK without disclosing beneficial ownership? Or, how do I, make sure I'm not subject to sanctions? So more from like a planning standpoint, from the standpoint of representing clients. And for example, Pandy, during your presentation, I was thinking, well, how would it work with the trust, right? A lot of our clients use trust, for example, both as a means of protecting assets, but also to disguise beneficial ownership. Are there structuring opportunities for clients who want to avoid disclosing their identity to the UK government? And you're muted, Pandy. There you go.
Thank you, Jacob. That's really an interesting question, because a lot of the comments has been as to saying, yes, you have brought in a new act that's going to target the corporate entities, but the reality is you have left out the trust structure. And of course, many companies and many good tax planners and many tax structuring, or at least corporate structures, now are saying to clients, well, actually, if you have a trust structure, then the obligation is not automatically there. And it's a question of what sort of a trust structure you have, then that would allow you to get behind this legislation and of course still hold your anonymity and withhold your beneficial ownership being disclosed to the effectively the company's register, which will happen in due course. So I think that is the real Achilles heel of this legislation. I'm sure, just like the way process of crime has been developing over 20 years, with more and more challenges and more investigative problems they face, I can see it actually changing over time, where I can see maybe in 2 or 3 years down the line, trust will also be brought into it. And of course, with trust, there's so many different variations to it. And I think that's where the problem is. It's not just simply saying a corporate structure where you have a corporate identity with directors and shareholders, and it's very easy to define who the influencers are. When you have trust structures and when you have many different variations in trust structure and many different variations in the countries and the way they operate trust structure, it is the current government's sort of a response as to why it's not currently included. But I'm sure there'll come a time when they will be able to define certain types of trust structure which may fall within it.
Thank you, Pandy. Very interesting. Interesting planning opportunities, I guess. And then I have one more question, and then I'll hand it off to everyone else for questions. But since I already have the floor, for Tim Mills. So Tim, I was wondering, while you were speaking, it's one thing to identify, specific individuals or specific legal or governmental entities that sanctions apply to. But I am sure sometimes you will have businesses that are not directly named in the sanctions, but somehow sanctions will impact their ability to buy goods. Maybe there's some components coming from a sanctioned player or what have you. Can you talk a little bit about how sanctions may impact sort of innocent third parties?
Yes, certainly. We, of course, in April, Aliant, John Wolf and I published a paper on this, and examples. The sanctions on Russian banks and the shutting down of the SWIFT network has meant that if you are participating in a commercial transaction in which you are selling to a Russian entity, even if the Russian entity is not sanctioned, and your payment was going to come through one of these banks or a letter of credit from one of these banks, suddenly you are faced with an inability to be paid for your goods. Do you have to perform the contract, yes or no? Well, obviously, if payment fails, you don't have to perform. That's one example. Another example is what I call the extra sanctions effect, meaning, outside of sanctions, the fact that shipping companies are no longer shipping to Russia. It's very difficult to find anyone that is flying anything into Russia from the European Union or any of these sanction issuing countries, as well as Maersk and other shipping companies cannot obtain insurance to go into a Russian port with their ships. So shipping itself has been affected. To the extent you are buying anything from Russia, from a Russian corporation, and they can't get it out to you, then you're going to be affected, and you'll have to figure out what your rights are under your contract, and we address that in the paper that's available on our website. Those are two examples. But in terms of, let's say, dealing sanctions, what you have there is OFAC, the Office of Foreign Asset Control, publishes what they call the SDN list, especially designated nationals list. And that list is available in electronic form, it's available in paper form, and it's massive, I might add, incorporating not just the Russian sanctions, but all sanctions programs. And that's your starting point for figuring out from the US side, if you're a US person, whether or not you are dealing with a sanctioned party. What's more difficult to understand is whether, say, for example, when you're dealing with a newly formed LLC, such as a Dubai LLC, limited liability company, whether that is the beneficial owner of that company is a sanctioned individual or not. And thus you end up having decisions to make about whether you take the risk if you can't identify who it is, but it looks very interesting and perhaps suspicious. As to banks, banks have under their KYC, know your customer regulations, and anti-money laundering compliance, they have what's called a CTR, currency transaction report, and a suspicious transaction report. Anything that looks suspicious is reported and to Treasury. And in many instances, banks are just saying, I'm sorry, but we're not going to deal with anything Russian, and we're just going to shut down any transactions dealing with Russia, even though they might not be per se blocked by sanctions.
Interesting, thank you. Something for all of us to be aware of. Okay, and by the way, we have on our panel today two other lawyers. We have the managing partner of Aliant's UK office, Sandeep Patel. Sandeep is also Queen's Counsel and a prominent commercial litigator. Hi, Sandeep. And then we have Jefferson Larry from our Paris office, and Jefferson is the head of our France practice, and also a prominent both a litigator and transactional lawyer. So they're both here to answer any questions you guys have. So I think I see some questions coming through both the Q&A box and the chat box, and we have a raised hand. So perhaps Jefferson and Sandeep, you can take these questions.
Okay. Hello, everyone. I see there's a raised hand from Michael Bono. Does Michael want to? I haven't seen anything in the chat box to indicate what the question is, but if Michael just wants to say it.
Yes. Okay. Can you hear me?
Yes.
Okay, good. So Jacob, in his last question, touched on something that I'm going to ask. What do you do if you uncover strong circumstantial evidence of a party or parties involved in both money laundering and sanctions violations? And a component of that is, what if the vehicle that's used for this scheme is something that a client has an interest in, an innocent third party? And just to give you a practical example, we heard earlier how ships and shipping in the shipping industry is used often for like in India, Russian tankers bringing oil to India, and then that oil being sold to European customers to get around sanctions. This has been going on a long time, much longer than in Russia, in Venezuela. And Venezuela has the cheapest fuel in the world, whereas we're paying in the United States around $4.50 or $5 for fuel. Venezuela, I just saw a report, is selling it for less than 10 cents a gallon. So the largest cost in shipping typically is the fuel costs of the ships. And so this is a very tempting, this tempts a lot of operators who are in the Caribbean, and there's mechanisms to get Venezuelan fuel and violate the sanctions regime by Venezuelan tankers going out to a known area. There's an anchorage off of Aruba, and doing ship-to-ship transfers to another vessel, and they bring the fuel to a country that is technically part of the sanctions regime, but really doesn't have the resources or the interest in doing anything about it, like places like Haiti or the Dominican Republic. And my client is a mortgagee, has an interest in the ship that was engaged in this, and I'm getting ready to seize the vessel and arrest it to foreclose the mortgage in Panama. And I see this scheme, but I also don't want to do anything to hurt my client's interest. My client wants to get the vessel and sell it and pay off the mortgage. So what do I do in that situation? I have a duty of loyalty to my client, but I also see strong evidence of a broad network that is basically using Venezuelan oil, using ships as intermediaries, and then part of the proceeds of those sales goes to Venezuelan oil officials, who then buy out Venezuela.
Right. So from your question, you say, what do I do? What do you mean as a lawyer? Well,
yeah.
That is ethical and professional, really. If you are aware that your client either inadvertently or advertently is involved in sanctions busting, for want of a better description, you would want to get to the bottom of that if it's inadvertent. If your client said,
my client is not. My client was an innocent party loaning money on the ship, and then the operators were involved later in my investigation, uncovered that they were involved in this scheme.
I mean, it's a tricky question then. I mean, I think I might hand that over to Tim. I mean, any indirect support would be considered to be in breach of the sanctions regime. So whether that would amount to that or not is a question of fact, really. If it's after the fact, then there'll be a different matter. But in a clear case where you become involved and he continues to lend assistance as a mortgagee, then he runs a risk, doesn't he, of being prosecuted?
Well, the mortgagee is trying to stop this and take back the ship. And had no knowledge of any of this. So
okay, then I mean, I suspect Tim spoke about the whistleblowing regime. I imagine that's anonymous. I think that is, and I imagine that would be that you may want to advise your client to do that. Then,
well, let me touch on some of the subtleties of the law in the area of sanctions. First of all, as a lawyer, is what has been communicated to you a client confidence. If it's client confidence, then obviously you have a legal obligation, ethical obligation to not disclose it. If it's with client approval that you would go forward to disclose it, then if, say, for example, the ship is currently bearing sanctioned Venezuelan crude, the U.S. government would be quite interested in your cooperation and would be inclined to cooperate with the arrest of the ship and the arrest of the oil cargo. This has happened before, by the way, and the U.S. government would take possession of the oil cargo and with the cooperation of the Panamanians where it sits, because you're going to have Panamanian judicial process for the arrest. And that would get litigated whether or not that's an asset that the Panamanians would permit the U.S. not only to freeze, but to seize and then sell. And therefore, sometimes these things go better when you are dealing cooperatively and simultaneously with the authorities. And of course, they're not going to seize the ship per se if they have a third party lien on the ship and the third party is an innocent. Then the U.S. government does permit under that circumstance the sale of the ship. If there's any excess proceeds, meaning above what's owed, then that excess proceeds, if the ship itself were sanctioned, would then go to the U.S. government as part of blocked assets, not seized assets, blocked assets. So that's one way through. But the other way is that if, say, for example, your client and therefore derivatively you have more information and extensive knowledge about this network and how it's working, then there's an opportunity to work with the Treasury Department and come under, again, this new rewards program, particularly if it leads to further seizures.
Okay.
And
Thank you.
Sandeep, you raised a question, and it's an apt one, very apt, of whether, say, for example, a whistleblower's communication of information, is that going to remain confidential? And the answer is, it certainly will remain confidential, not disclosed publicly, and protected inside the U.S. government, so that the whistleblower itself is not endangered. And oh, by the way, who wants to tell the U.S. government this, this, and this if it's going to end up being public, and then the whistleblower is going to be targeted by evildoers or wrongdoers or miscreants, however you care to call them. Even the payments, payments under the Whistleblower Program, this is public monies, of course, that are being paid. And you would expect that the expenditure of public monies would be a public record. But in fact, yes, the rewards paid are identified, but to whom the report paid to, that's not public information for a number of years, as in like 5 years, 10 years, when it no longer makes a difference.
Could I come in here? I feel I really need to, because this is very important, because I do a lot of work in the Eastern Caribbean on money laundering and confiscation of assets. And this raises a real problem way beyond the US jurisdiction. Your client, in sanctioning even the passage for 1 nautical mile of that ship, may well be committing a criminal offense. It goes way beyond legal professional privilege. First of all, the ship will be regarded as the instrumentalities of unlawful conduct and is liable to confiscation. And that confiscation will take priority over any mortgage. So my advice to your client in those circumstances is you need to get in contact with the financial intelligence unit for the particular country, whether it's in the Caribbean or the US. It's probably in the Eastern Caribbean, and you need to make a disclosure to them, because otherwise you are going to be in great trouble, not just your client, but you as a lawyer as well. And once you've contacted the FIU in confidence, they may well give you permission to carry on with the course of conduct. But if you don't, you're going to get your clients into really deep trouble, because that ship is worth a lot of money. And if it's deemed the instrumentalities of unlawful conduct, it could be confiscated. And that confiscation will take priority over your client's mortgage. So this is not a lightly thrown overboard, forget the pun, problem. You've really got to address this with your client and advise them.
That's what we would call a collusion under French law.
Oui, absolutely.
I agree with all that. My point being that under the ethical rules of a client confidences, it's the client that has the obligation. Of course, the lawyer then has the obligation to counsel the client that they should follow this course of action, which is exactly what I was advocating. In the US, that financial intelligence unit is called FinCEN, US Department of Treasury Financial Crimes Information Center.
But be careful, because you can't rely on legal professional privilege if you're charged with aiding and abetting money laundering.
No, agreed. But I'm saying to keep yourself out of trouble professionally, you make a record that you communicated with the client and you advise the client, and then you have a more thorny issue if the client doesn't follow your advice, and have you put yourself in a position of being deemed to be conspirator or a neighbor and a better.
Yeah, precisely. Then you've got to make a report to the FIU, definitely. It's a very tricky area, very.
And that's why people like us are valuable, because it is a tricky area.
Great advice.
Thank you for that.
Okay, can we move on to the next question? Next question would go to Menika and probably I would think also to Nikita. You were both mentioning, I think in India, I heard that the process was the sanction. And I heard that in Italy, there was possibility for interim disqualification measures. So the question is the following. is there any claim for compensation in the case where there is finally no prosecution, or where finally the legal entity being prosecuted is found non-guilty? Is there any claim for compensation?
Should I just go first?
Please.
That'd be
go
all
ahead.
right. So in India, there really isn't any possibility of compensation. We've not had a case thus far when it's come to, kind of vexatious prosecution, if you will, of allegations of white-collar offenses. Though I think, as a lawyer, when you kind of see the volume of prosecution, the volume of investigations, the volume of asset seizures that have been launched in the last couple of years, and how that has impacted clients, their businesses, shut down, well-established businesses, you have to wonder whether it's not time to make that kind of claim for compensation. But one of the reasons why there hasn't been a judgment of compensation is that, in India, the kind of the civil law, tortious law, the foundations are quite nascent, quite weak. So this notion of compensation by the state for, if you will, a kind of an old kind of like a vexation prosecution hasn't really taken root. But that's maybe now's the time to think about it, to initiate such an action. But yeah.
Okay. And Nikita, what would be the situation in Italy?
And thank you, Jefferson. Well, the subject of the civil liability of judges is very discussed in Italy since many years, and we have a law, but it's nothing to share with the 231 decree. And actually, very, very rarely, judiciary mistaking can lead you to get compensation or refund. So on your specific question about disqualification interim measure, I would say that you will never get a refund or a reimbursement, unfortunately. That's why I've been pointing the attention of the audience on that subject, because you can get a disqualification from exercising the activity that could mean in 1 year that you are dying, you are dead.
Okay. Okay, thank you very much. We have a question for Paul Garlick. How does the UK government expect? How does he expect UK government proposal to come out of the European Court of Human Rights? And how would this affect the extradition process in the future?
Right. Okay. Well, I have to suppress my own personal opinions about this. But as a lawyer, first of all, if he tries to come, if our government tries to say that our courts and our executive are not bound by the decisions of the European Court of Human Rights, that will result in action by the Council of Ministers of the Council of Europe against the UK. It would almost inevitably, if we didn't back down from that position, result in us being expelled from the Council of Europe, which would make the UK on the same real playing field as Russia. Russia was expelled from the Council of Europe 2 months ago. They tried to leave the Council of Europe, but the Council of Ministers acted very quickly and expelled them before they could just leave. I think we would definitely have to leave the Council of Europe, which would make the United Kingdom the pariahs of Europe. So if you were a judge in any EU member state, which is smaller than the Council of Europe, or the Council of Europe, which is 46 member states, and you were faced with an application for extradition by the UK asking for someone from your country to be sent back to the United Kingdom, and the defense lawyers stood up and say, look, this is a country which is now withdrawn from the jurisdiction of the court in Strasbourg. They've just been thrown out of the Council of Europe. Is the judge likely to be well disposed to granting extradition to the United Kingdom? I think not. It's an absolutely ridiculous course of action. It's motivated by populism and election gathering, and it will be disastrous for the country, for our rule of law. And I think most judges in the United Kingdom would resign if we withdrew from the European Convention of Human Rights. It's just absolutely appalling.
Okay.
Sorry, I'm quite strident about this, as you can hear.
I was going to ask you what were the reasons for withdrawing from the European Human Rights Convention, but you almost already answered it.
I can tell you immediately, the European government, the UK government does not like being criticised by the courts in Strasbourg, and they regard it as an affront to their rights to do anything that they want to do. Notwithstanding that they have an international law obligation to obey all the articles. I was talking to a minister recently, and I said to him, okay, you say that we should withdraw, that the European Convention on Human Rights is causing difficulties in the problem for the UK. So I said, okay, look at the rights under the European Convention. Article 2, the right to life. Do you have a problem with that? No, he said. Article 3, the right not to be tortured or to be exposed to inhumane or degrading treatment. Do you have a problem with that? Well, I guess not. The right to life. Do you have a problem with that? No, I guess not. So what's your problem with the European Convention? And he said, well, it's because we don't have the final decision. And I said, but the European Court of Human Rights is a supervisory jurisdiction. It means when you've exhausted all your local remedies, your domestic remedies, and you still haven't got a fair hearing, you can go to Strasbourg. And he said, okay, maybe. So I think this is just a hopeless argument by our government.
Thank you, Paul.
Okay. Jacob, sorry to intervene, Jefferson. Jacob, have we got any more time?
I think I think we should wrap up the Q&A session to stay on time.
Okay.
And I think Pandy had some concluding remarks for us, if I remember correctly.
Yes, that's correct. But I think there was one question which I wanted to ask Menaka, if I may take the opportunity. It's interesting to see how Menaka was talking about the lack of rights in the money laundering course, as they would call it. And how does Menaka see the fight against economic crime, fight against money laundering, bribery, corruption, sitting with the fundamental rights, which are, right to legal advice, right to be able to know what the charge against you is, right to know what sort of a time frame that you should be investigated in, because Indian courts and Indian investigations take many, many years before it comes to it. So really, as for the fundamental question is, how do you see the balance between the human rights on one end and the fight against the problems that arise as a result of significant and very complex economic crimes?
Yeah. Well, thank you for that question, Pandy. But I think it's twofold, right? It is astonishing to me as a practicing litigator to have and the scale of laundering as an offense. I mean, let us accept that there's a lot of it. Let's start with that assumption. But to me, as a litigator, I am astonished to see these low conviction rates, leading me to believe that in other areas of criminal practice and criminal law, which involves serious crime, where we do have these protections in place, judges feel more comfortable convicting. Prosecution makes a stronger case. As a defense lawyer, I have a higher expectation of skill set to meet that case. And I think all of this results in judges being more comfortable because they see this kind of cogent evidentiary scheme that is put before them. And I did see your previous question also on burden of proof, which has been, the different burden of proof, which has been upheld in the UK and has been upheld in India as well. I think to have a different standard of burden of proof is one thing, but to take away basic constitutional protections, to be interrogated day on day for a week at a time without a counsel present, you alone in an interrogation setting with multiple officers, it really behoves, the question that needs to be asked, is this how we fight crime?
Absolutely. I mean, it's a really, really interesting question. And it goes to the type of investigation and how does investigation to take place. I know
Yes.
we have had what we call PACE since 1984, and Sandeep is an expert on that, having done many of those. A lot of the procedural safeguards in the UK, we only had them in the last 30 years. I mean, Sandeep, did you want to comment on how it was pre-PACE, which is the Police and Criminal Evidence Act? In terms of
very briefly, Andy, you're introducing me because I'm very much older than you and can remember things when you were not born. So that's very kind of you to ask me to do that. Yes, I mean, I think one of the things we could discuss in this discussion, Monica, some time, because one of the things I did want to ask Monica was about the test of proportionality. And to what extent at all was that important in your arguments in the Supreme Court? Because we had a big decision here in the United Kingdom where in 2012, which dealt with human rights. You've got the Human Rights Act, you have the Constitution, but most importantly, the test of proportionality, where the lordship said that's most important. When you mention that in the context of the benefit is X, but the court finds that the potential price of the crime is 200 times X, that's disproportionate. Is that something that's going to feature in the judgment of the Supreme Court when it comes out, which I'm very much looking forward to reading? I'm sure it'd be a great success.
Well, you know, it's been argued, Sandeep, you know, proportionality and the disproportionality has been argued in this case. You know, if I look, I've practiced what 24 years at the Supreme Court, and now you have a sense of various judges and panels. I think, let me put it this way, that I think it is important to argue these cases. I'm not going to publicly tell you what I think the outcome is going to be, but I think as lawyers it is very, very important for us to argue these cases for our clients, irrespective of what we think the outcome is going to be. So yes, I'll leave it at that, and I hope that we can have chat further, Sandeep.
I look forward to that. That's very diplomatic of you, and you ended where what reminded us of what we all are supposed to do is simply represent our clients to the best of our ability.
Absolutely, absolutely. But I look forward to taking this conversation forward.
Thank you.
Yeah.
Thank you, Monica, and thank you, Sandeep. I think, as is clear, these are really vital issues, and it doesn't matter which angle you look at it from, whether from an enforcement, whether from a litigant, whether from a lawyer's perspective or a judicial or criminal process. These have all different ramifications for all of us, and it is really, really interesting that we have had an opportunity to discuss that. With the last 2 minutes, I'll just take my opportunity to say thank you to all the wonderful panelists. It's been really an interesting and you know, from my perspective, riveting discussions on some really amazing legal issues that we are looking at it from many different angles, starting with Tim in America. It was really interesting to hear how the sanctions bites and how the sanctions will play going forward, and that in context of everyday developing situation. And then, of course, really interesting to see and hear from Nikita as to how things are in Italy, particularly from the provisional measures point of view. And of course, hearing from Paul, it's really interesting to see. And of course, his views on European Court of Human Rights and withdrawal from that is shared by many, many lawyers, including myself. And I think it'll be a travesty if the UK government decides to do that, because it will have a great deal of impact, not only in the extradition context, but I also think it'll have in the international mutual legal assistance, MLAT, cooperation between countries. And thank you, Paul, for that great presentation. And of course, Monica, thank you for being our guest speaker this year. We are delighted you could make time and join us, and it's been a really interesting conversation. And we're very grateful for the opportunity given us to hear you.
Thank you for having me.
Thank you. And of course, Sandeep and Jefferson, thank you so much for hosting Q&A, really interesting topics and discussions which has come about, and it's fantastic to have that. Jacob, thank you for having and shepherding us through this. Really interesting and a delightful second economic crime conference. Last but not least, thank you to the organizers, Kim and Kamola, who've done amazing amount of work in the background to make sure we all attend on time and have all the preparation in play, and we really appreciate for all the hard work. And finally, thank you to all the attendees, and I hope you found the webinar, the discussions really interesting and illuminating. And as we said at the beginning, we are happy to have any questions answered offline, just write to us, our contact details are there. So in the meantime, all there's for me to say, wish you all well, and thank you very much. Bye for now.